Szia, Márti!
Szia, Zsuzsa! Hallasz?
Csak mi ketten?
Igen, egyelőre. Csak azt szerintem nem, a kamera valamiért egyelőre nem jó.
Igen, húzd el. Nem az, hogy be van
Elvileg ki van oldva, úgyhogy nem tudom.
oldva?
Ja, ott fönt kihúzta, igen.
Na, látod, én is azt, múltkor, amikor ilyen fura, tehát hogy látszik, hogy valami akkor ott fönt a kamera. Igen, amit régen. Hello!
Hi.
So it's 6 p.m.
Yes.
Let's start. And will I check if everyone is present? Okay, give me a moment. I don't see Professor Erika. Do you know what happened with
As always. As always. This is the usual.
Unfortunately, yes.
Actually, she knows.
Don't know anything.
Could you call to our friend Erika and invite her to our meeting?
Yes, I will call.
I will be grateful. Thank you.
And I'm grateful your flexibility, all of you, to delay this open seminar because of my asking of the concert, but I had a COVID always, so it was very difficult. The last 2 weeks wasn't my best weeks ever.
So it is good to see you the whole and good in a good health. I hope.
So. Not 100%. My voice is not good.
Maybe not on 20 minutes presentation.
Yes, it's not problem. I will. Unsuccessful. I couldn't reach Erika.
I understand.
Sorry, I
will once again, everyone, and welcome to the first open science seminar on protection of the elderly. I'm glad to see almost all members of our team. Today's seminar will be a bit longer, I suppose, than the last one, but I hope it will be inspiring. Each team member today has 20 minutes to give a presentation or lecture. Then there will be time for a short exchange of opinions, maybe for giving questions. According to our agenda, we will start it with the presentation or lecture of Professor Zsuzsa Wopera's presentation. Could you start?
Yes, of course. Thank you very much.
Thank you very much.
So, dear colleagues, dear research group member, dear participants, good afternoon, all of you. In the focus of my today's presentation will be the analysis of the right of contact of elderly relatives in Hungarian private law. When I choose the topic of the contact rights of elderly relatives in the legal protection of elderly research group, I didn't think that it was such a topical issue. In more and more EU member states appears this issue as a problem of legal practice, as a result of which more and more EU member states are extending the right of contact with the child to persons other than the parents, especially to elderly relatives. In my paper, I will present the current Hungarian legal regulation and important jurisprudence, the relevant international and EU connection points, and the possible future direction of the legal regulation. Let's start with the international and EU legal connection points. The UN Convention on Rights of the Child clearly establishes the child right to contact. According to the Article 9 of the Child Convention, the states parties shall respect the right of the child who is separated from one or both parents to maintain personal relation and direct contact with both parents on a regular basis, except if it is contrary to the child's best interest. This was the ninth article of the Child Convention, as I cited. In accordance with the Child Convention, Hungarian civil law ensures the child right to contact. The basic rules of contact are in the Hungarian Civil Code. The Civil Code basically regulates the right of contact between the parent who living separately and the child. According to the Civil Code, the child shall have the right to maintain personal and direct contact with the parent living separately, and the parent living separately from the child shall be entitled and obliged to maintain contact with the child. Since the right of contact can also be interpreted between parent and child, the right of contact of relatives other than parents is not obvious in the absence of a concrete legal regulation. We rarely talk about that in 2003, the Council of Europe adopted a convention on contact concerning children, which entered into force in 2005. Unfortunately, only 19 members of Council of Europe signed the convention, and only 9 members of Council of Europe ratified this convention. Poland signed the convention in 2003, but didn't ratify, while Hungary neither signed nor ratified it. It's bad news for us and for the children and the regulation of the contact rights. This convention authorized the member states to define the circle of persons based on close family ties who can have contact with the child. According to the Article 2 of the Contact Convention, family ties means a close relationship, such as between a child and his or her grandparents or siblings, based on law or on a de facto family relationship. The explanatory report of the Contact Convention pointed out that the determination of the persons, in addition to parents with whom a child may have contact, subject to the best interest of the child, is of a crucial importance. The most recent regulation relating to this matter has tended to broaden the circle of the person who has contact. The European Court of Human Rights pointed out in the connection that family life within the meaning of the Article 8 of the European Convention on Human Rights includes at least the ties between near relatives, for instance, those between grandparents and grandchildren, since such relatives may play a considerable part in family life. In the EU law, the grandparents' right to contact also meant uncertainty. Advocate General Spooner, in the case Nelly Varcheva versus Georgios Babanarakis, pointed out that the contact between grandparents and their grandchildren, in particular, in an ever-changing society, remains an essential source of stability for children and an important factor in the intergenerational bond, which undoubtedly contributes to building their personal identity. In the Babanarakis case, the European Court of Justice made it clear that the concept of right of access, it means the right of contact, referred to the Brussels 2A and now the Brussels 2B regulation, must be interpreted as including the right of access of grandparents to their grandchildren. And after that, look at the Hungarian regulation, as I promised you. The Hungarian Civil Code entitled other relatives to contact with the child for persons other than the parents, including the grandparents. According to the Hungarian Civil Code, the grandparents, it's a citation, the grandparents, sibling, and if the parent and the grandparents are not alive or are permanently prevented from having contact with the child or do not exercise the right of contact on their own fault, the sibling or parent of the child parents shall also be entitled to have contact with the child. This is the end of the citation. The Civil Code therefore precisely defines those relatives to whom it has the right of contact with the child. Among elderly relatives, the civil code designates the grandparent's right of contact with the child, with the grandchild, of course. This means that, for example, such a right of the great-grandparent cannot be enforced based on the civil code. The need to regulate contact between grandparents and grandchild also arises, of course, when there is no agreement between the parents and the grandparents on this issue. Based on judicial practice, the question of contact with the grandparents arises most often and most critically when the parent dies and the other parent doesn't allow contact with the deceased parents' relatives. It makes the situation even more difficult if the surviving parents find a new partner or gets married, because in this case, the contact with the deceased parents' relatives is even more in the background since the child has a new family. Let us see what procedure is available in Hungarian law to the grandparent in the case of the parent doesn't allow contact with the grandchild. According to Hungarian procedure law, if there is a dispute between the parties regarding contact with the child or the grandchild, the court or the guardianship authority decides. The court shall decide on the contact when the child, if there is a divorce action or a parental custody action pending between the parties. In all other cases, the guardianship authority decides, including if the grandparents' contact rights must be regulated. It must be emphasized that the court of guardianship settlement will only take place if there is no agreement between the parties on the exercise of contact. In the procedure aimed at the regulating contact, any interested party and the child who is of sound mind shall be heard. The guardianship
I didn't see her. We have a problem with contact. Yes, maybe we will
yes,
give her a chance.
She's back.
Yes, Zsuzsa, do you hear me?
Yes. Is there any problem?
Yes, it was a short problem with your speech, but I think it will be everything okay. Could you continue?
Is there any problem?
Do you hear me, Zsuzsa?
Do you hear me?
Yes, I hear you.
Yes, of course.
Yeah, go on.
Was there any problem?
Yes, it was.
It was. When did you lost me? When?
Exactly half a minute ago. So it's I don't know why.
I don't know, because my internet relation is good. I heard you. Erika is arrived. Do you hear me, Erika? Marty?
Yeah.
Okay, so can I continue?
Yes, please.
Yes, okay, I will continue. So if the guardianship authority dismisses the request for contact, it can be challenged in court in an administrative court action. So ultimately, the court makes the final decision in the case as well, but not in a civil court action, but in an administrative court action. This is remarkable, and this is very interesting, because the substantive legal rules of contact are clearly private law rules and not public law rules. So it should be emphasized that in the administrative court action, the issue of the contacting may even reach the Curia is the Supreme Court of Hungary, in a review procedure. So the Supreme Court can even adopt a decision in the matter of contact between grandparent and grandchild. We know that according to the Code of Administrative Court Procedure, the party cannot automatically bring its case before the curia. The curia decides on the admissibility of the review application in each case. It should be noted that the curia recently accepted many cases, so the highest judicial forum can have the final word on legal issues of grandparental contact. In the following, we will summarize the most important statements of the jurisprudence of Supreme Court related to grandparents. I would like to ask you that, do you hear me? Okay, thank you, thank you. So, the most important statements of the jurisprudence of the Supreme Court related to grandparents' contact. The Supreme Court found that the grandparents' right to contact is a right, but it doesn't necessarily guarantee the right to contact their grandchild, regardless of the circumstances. Contact must be regulated in all cases and primarily regarding the best interest of the child. When deciding on the issue of contact, the child's best interest must be taken into account, which may conflict with the right of the contact of the grandparent. It is not the best interest of the child to have contact that causes shock and significant harm to the child. Grandparent contact, this is the third statement, grandparent contact can be decided at the guardianship authority discretion. The guardianship authority shall provide the reasoning is discretionary decision. The grandparent has the right to maintain contact independently and not jointly with the parent living separately within the period of his or her contact. The next is the right of contact between the child and the grandparent is a fundamental constitutional right, a child right, and a basic human right, but not an independent personality right. It is common reference for the grandparents to request contact with their grandchild on the basis that this is a part of their personality right to privacy and full family life as defined in the civil code, but it is not an acceptable interpretation according to the jurisprudence of the Supreme Court, because the right to contact between the child and the grandparent is not an independent personality right. The curia emphasizes that the parental and grandparental contact are two separate and independent rights in themselves. They are not dependent on each other, and there is no order in their regulation, regardless of whether it is done by the court or the guardianship authority. The next is contact between the parent and the grandparent cannot lead to the withdrawal of the right to contact with the grandparent. With this reasoning, the grandparent's right to contact cannot be denied. The grandparent contact rights cannot be derived from the parental rights. It is a wrong point of view that contact with the grandparent can only be ensured if the parent's right to contact is not violated. With such an interpretation, the legal provision ensuring the grandparent's contact would become empty, and in the absence of an agreement between the parties, the enforcement of the grandparent's right would be impossible. The purpose of the contact is to maintain and further deepen the relationship with the grandparent. The fact that the grandparents didn't have a close relationship with the children due to a family conflict is no reason not to continue to have it, as children not only have an interest, but also a right to know their family relationship. It is essential for their own personality development and strengthen his own roots. So finally, let me evaluate the Hungarian legal regulation of contact rights of grandparents, and let me give some the lege ferenda proposal. Hungarian civil law guarantees the right of contact of grandparents among elderly relatives, established by law according to the provisions of the International Legal Convention in force, not in Hungary and not in Poland, but the other member states, and the provision of the EU law. The Hungarian jurisprudence consistently applies that the grandparent's right to contact is an independent of the parent's contact right, and the grandparent's right to contact cannot be restricted because of the bad relationship of the parent and the grandparent. In Hungarian jurisprudence, the principle according to which the child's best interest is ahead of the grandparent's right to contact is consistently applied. With regard to the right of contact of elderly relatives, the question arises as to whether the line can be drawn as to who can have the contact with the child. The civil code among elderly relatives ensure the right of contact for the grandparents. But can the great-grandparent contact right be limited on a constitutional ground? The general conclusions regarding the protection of the family can be drawn from the fundamental law of Hungary. The state must guarantee contact within the family, especially between those relatives who are in a direct kin relationship, including the great-grandparent right to contact. On the one hand, it would be well-founded to extend the range of persons entitled to contact to all elderly relatives who are in a direct kin relationship. According to the civil code, lineal kin relationship exists between those of whom one originates from the other. So this is the kin relationship. Because there is no constitutional basis for the law to withdraw the range of persons entitled to contact at the grandparent level. This proposal is harmless.
Yes, we have a problem again.
With the concept of mentioned contact concerning children.
Professor Zsuzsa, we have a problem with your connection. Professor Zsuzsa, do you hear me? Rather not. I think we will a minute for new attempt to contact with us. So maybe we stop with her presentation. Professor Zsuzsa, do you hear me?
Should I call her? Oh, she's back.
Maybe.
I will try to call her.
Something happened.
Yes.
Ugye nem az internetemmel van gond.
Egyszer csak megáll, és nem hallunk téged egyáltalán.
Hello.
It was a problem with your conclusion because internet stopped.
Igen. Yes, but I think it wasn't my internet problem. Do you hear me?
Yes, please. Yes, continue.
I think it wasn't my problem. So I have only 2 minutes.
Yes,
Can I
please.
finish?
Yes. Yes,
okay.
If possible, go on.
Okay, I just 1 or 2 minutes. So I will repeat because this is the closing remarks. So on the one hand, it would be well founded to extend the range of persons in contact to all elderly relatives who are in a direct kin relationship. The direct kin relationship is a lineal kin relationship between those of whom one originates from the other. So it would be well-founded if to extend the range of persons entitled to contact to all elderly relatives who are in a direct kin relationship, because there is no constitutional basis for the law to withdraw the range of a person entitled to contact at the grandparent level. This proposal is harmonized with the provisions of the cited international legal convention, in particular the Council of Europe Convention on Contact Concerning Children, and with the European trends that has tended to broaden the circle of persons who has right of contact. On the other hand, the child's private life must also be taken into account when broadening the circle of the person entitled to contact. If we imagine if the child has to maintain contact with his separated parent, with his 4 grandparents, and with this 8 great-grandparent, of course, I know that it's a very extreme situation, then his life will consist of a series of contact, and he will not have time for activities due to his age chosen by him, which is absolutely contrary to the child's best interest.
We lose contact with her again. In my opinion, the problem is on her side. So maybe we finish with her presentation on this point. Unfortunately. And let me now outline my lecture. I hope it will be maybe better on the connection issue. My presentation concerns children's responsibilities for the elderly parents. At the beginning, parents and children should support each other. This stems not only from moral reasons and principles of social coexistence, but also from the law. According to the natural order in childhood, the duty to provide support falls on the parents. With the development of a child's independence, this is gradually reduced and, as a rule, ceases as soon as the child is able to support themselves. As time passes, the child's parents grow older, which means loss of strength, earning capacity, and above all, health. Consequently, they may themselves need help from their children. Helping the parents is a basic duty incumbent on the child, which can be done in many ways depending on age, situation, and needs. With the above in mind, a number of questions arise, namely, are there any provisions obliging a child to care for an elderly mother and father? Can a child caring for their parents benefit from state support? Is the child entitled to a care leave from work and attendance allowance for elderly parents? Does the law provide for enforceability of the obligation to support elderly parents? In seeking answers to these questions, we should first refer to the provisions of the Family and Guardianship Code, which contains provisions designed to protect the relationship between parents and children. Article 87, according to which parents and children are obliged to respect and support each other, is of fundamental importance. The aforementioned obligation does not depend on the parents being married, nor on whether the child is a minor or an adult. it is accepted that mutual support means mutual assistance, which can be both material and non-material. The obligation of mutual support between parents and children lasts until the death of one or the other. In the case of non-material support, it involves visiting all parents, psychological support during illness or disability, intellectual help with important decisions or life issues, and physical help with various daily activities that may cause difficulties. Material support, on the other hand, mainly means the fulfillment of the maintenance obligation towards the parents, understood as the provision of means of subsistence in money or in kind. It should be added that care leave is granted for caring for a sick family member. This right applies to the child as well as the elderly. Every employee has the right to care leave regardless of the duration of work and the type of employment relationship. Care leave can be taken for a maximum of 14 days per year. The employer may not refuse to grant leave provided that the person concerned remains in a joint household with a sick family member and is the only person who can provide the necessary support in the event of illness. Employees covered by sickness insurance are additionally entitled to attendance allowance. The prerequisite for obtaining the leave and the allowance is a medical certificate of temporary inability to work due to the need for personal care of a sick relative. In cases of a serious illness or disability, the consequence of providing round-the-clock care for a parent is the need to give up gainful employment. Caring for sick or disabled people requires a great deal of dedication and financial resources. In such situations, carers are entitled to public benefits such as attendance benefit, family allowance, or carers allowance, in addition to the attendance allowance. The care of sick or disabled parents should be carried out by all children. Thus, if parents were only in the care of one child, the child can pursue his or her claims against the siblings through the courts. The reimbursement of a cost for the care of the elderly parents may be the subject of a separate court action initiated an action for payment. It is accepted that it is impossible to enforce the children's duty of care towards their parents. However, one should bear in mind the regulation of Article 210 of the Criminal Code, according to which whoever abandons a person who is incapable of caring for him or herself due to his or her mental or physical condition shall be punished by imprisonment for a term of 3 months to 5 years. A vulnerable person is a person who, due to his or her physical, for example, old age, disability, bedridden illness, or mental characteristics, does not have the capacity to decide independently about their fate or to change their situation. Abandonment, on the other hand, means the action of abandoning in a incapacitated person combined with the cessation of caring for him or her without the care of others. The maintenance obligation which comes down to the satisfaction of the normal everyday consumption needs of those in need, is imposed on relatives in the direct line, that is, in the first instance, adult children. At the same time, the maintenance obligation of children towards their parents exists irrespective of whether the children live with their parents or separately, and whether they have established their own families or not. The implementation of the maintenance obligation is an expression of mutual responsibility and solidarity among family members, manifested in the provision of assistance to those who are weaker. The maintenance obligation may be carried on voluntarily, entirely gratuitously, or it may be imposed by a family court. There is no doubt that it is an obligation of an obligatory financial personal nature linking the maintenance beneficiary to his or her obligor. The existence and scope of maintenance obligations are regulated in a mandatory manner, with the result that they are the result of law if certain conditions are satisfied. The basic prerequisite for the creation of a maintenance obligation is the existence of a family law relationship between the beneficiary and the obligor. Other prerequisites include the inability of the person entitled to maintenance to meet his or her justified needs alone, and the financial or earning capacity of the obligor to pay maintenance. A child's maintenance obligations only comes into play in the event of parental privation. This means that only if the parents are unable to meet their own justified needs can they claim a maintenance from their child. A contrario, the scope of the duty of maintenance does not include unjustified needs and needs relating to the creation or increase of possession gained. If the beneficiary is able to satisfy his or her needs even partially by his or her own efforts, the obligor's maintenance obligation is limited only to the remaining unsatisfied part of the beneficiary's needs. However, in order to enforce the obligation, the child must have the earning capacity to pay maintenance. For example, he or she must be financially independent. When awarding maintenance, the court should take into account both the justified needs of the beneficiary and the earning capacity and assets of the obligor. However, for a parent to be able to claim maintenance from his or her child, the past behavior is important, as the onus is on them to prove that they contributed to the maintenance and upbringing of their child before the child became independent, and that their claim is consistent with the principles of social conduct. In practice, it often turns out that maintenance is sought by a parent who has neglected his or her child all his or her life, who has not cared for the child, who has not contributed to the child's upbringing, and who has not been interested in the child's fate, and who has not even had any contact with the child. they invoke a state of deprivation and the child's duty to support his or her parent. In such a situation, the child may claim that the parent's claim for maintenance is an abuse of his or her entitlement, and moreover, that is contrary to the principles of social coexistence. If the children cannot help the elderly parent, they are entitled to assistance in the form of care services or specialized care services, which mainly include assistance with daily living needs, hygienic care, and grooming, and providing contact with the environment. On the other hand, a person requiring round-the-clock care due to age, illness, or disability, unable to function independently in everyday life, and who cannot be provided with the necessary assistance in the form of aforementioned services, is entitled to be placed in a social welfare home. It should be added that both the provision of care services and a stay in a social welfare home are at least partially paid. The obligation to pay in the first instance rests with the recipient of support. If he or she cannot afford to pay, the obligation is passed on in turn to the spouse, children, and grandchildren, as a last resort to the municipality. The spouse and relatives of the beneficiary are counted as part of the beneficiary's family if they live and farm with the beneficiary. The municipality may not waive the payment of the fees for services provided to an elderly person in need of assistance. However, it has the right to seek reimbursement of the expenses incurred from the resident of the home, his or her spouse, children, and grandchildren. A review of these provisions shows that the duty to support elderly parents, especially the duty of maintenance, can be enforced, while a failure to help care for an indigent person can be criminally prosecuted. Thank you very much for your patience, most of all. And now we will go to the next speaker. I'm asking Marta Benyusz to take the floor.
Okay. Sorry. Good evening, everyone. Dear team members, thank you for the possibility to present my paper today. So the title of my today's presentation is the Regulation of Legal Capacity and the Regulation of Guardianship under the Civil Code in the light of the Article 12 of the CRPD. The first part of my research concluded that the only human rights instrument offering useful protection to older people is the CRPD. It concluded also that nevertheless it offers some protection to those elderly who have, as a result of aging, some kind of disability. It does not reflect the problems stemming exclusively from aging, and therefore does not address the problem of ageism, which causes a tangible gap in human rights protection. The second part of my research concentrates on this narrow but indeed existing protection and examines the implementation of CRPD into national law, focusing on the regulation of legal capacity and in this frame on the regulation of guardianship in Hungarian law. Therefore, in today's presentation, I would like to merely focus on Article 12 of the CRPD and its implementation. At this point, I would like to start from a broader scope and firstly try defining what actually was the purpose of Article 12 and what the Committee on the Rights of Persons with Disability has to say about the directions of implementation. In this field, I will present an outline of the general comments of the committee, which particularly addresses Article 12, and also the two concluding observations regarding Hungary. Whenever analyzing these documents, it is worth bearing in mind that while Article 12 incorporates a binding obligation under international law, the instruments coming from the committee, such as the general comments or concluding observations, are the result of a discourse in between the committee and the states and have no binding legal effect. However, they provide a level playing field for deeper understanding, interpretation, and further discussion, thus pushing international and national legislators into reviewing existing laws and practices. So what actually Article 12 has to say, and at this point, just shortly, how is it reflected in Hungarian law? Paragraph 1st of Article 12 says that state parties reaffirm that persons with disabilities have the right to recognition everywhere as a person before the law. It is indeed the case in Hungary. Everyone shall have legal capacity from his conception, provided that he is born alive. According to paragraph 2, state parties shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. All questions arise from this point and also from the Hungarian point of view from the limitation of adults' capacity to act. What more Article 12 has to say about that? It provides that state parties shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. State parties shall also ensure that all measures that relate to exercise of legal capacity provide for appropriate and effective safeguards to prevent abuse in accordance with international human rights law. Such safeguards shall ensure that measures relating to the exercise of legal capacity respect the rights, will, and preferences of the person, are free of conflict of interest and undue influence, are proportional and tailored to the person's circumstances, apply for the shortest time possible, and are subject to regular review by a competent, independent, and impartial authority or judicial body. The safeguards shall be proportional to the degree to which such measures affect the person's rights and interests. Subject to the provisions of this article, state parties shall take all appropriate and effective measures to ensure the equal right of persons with disabilities to own or inherit property, to control their own financial affairs, and to have equal access to bank loans, mortgages, and other forms of financial credit, and shall ensure that persons with disabilities are not arbitrarily deprived of their property. One might realize that Article 12, paragraph 1, so the term persons with disabilities have the right to recognition everywhere as a person before the law, echoes on Article 16 of the International Convention on Civil and Political Rights. When drafting this very important milestone international instrument, it was an important debate to distinguish between the rights that attach to an individual's capacity to have rights and the capacity to act on those rights. Article 16 did not address the issue of restriction. However, the commentaries to this provision assumed the possibility of restriction and did not consider it as an infringement. Legal capacity to act is a legally recognized status of those persons who have reached the age of majority to make binding legal arrangement with others. Central to this capacity is to be one to whom legal obligations and rights attach. In Hungary, for instance, one's legal capacity to act can be partially or fully limited on several grounds, from which a legitimate ground can be a mental disorder resulting from aging. These persons are put under guardianship, while actually Article 12 calls for an end of such laws, or at least for a very strict review from a point of view of the rights-based approach followed by the CRPD. What does the general comment number 1 on Article 12 say about it in details? It actually underlines precisely that equality before the law is the basic general principle of human rights protection and is indispensable for the exercise of other human rights. It underlines as well that Article 12 does not set out additional rights, but it simply describes the specific elements that state parties are required to take into account to ensure the right to equality before the law for people with disabilities, only for disabilities and not only for disabilities as a result of old age, on an equal basis with others. The committee also highlights a general misunderstanding of Article 12, which actually calls for tangible end of substitute decision-making, such as guardianship or custody, and the adoption of real supported decision-making processes. From the general misunderstanding, a holistic examination of all areas of law would arise, as it actually requires a thorough investigation and overview of existing legal instruments. The examination should particularly concern those who lose their mental health and thus have either cognitive or psychological disabilities as a result of aging as well. In the view of the committee, it can never serve as a legitimate ground for denying legal capacity. The general comment focuses primarily on the normative content of Article 12. As regards the first paragraph, it emphasizes that this provision guarantees that every human being is respected as a person possessing legal personality, which is a prerequisite for the recognition of persons' legal capacity. As it was mentioned already before, this is absolutely met in Hungarian legal system. If we look at the text of paragraph 2, we see that it recognizes the legal capacity of disabled, also the ones that are disabled as a result of aging. And at this point, the general comment points out a very important difference that needs to be made. This is the clear distinction before one's legal capacity and mental capacity. Legal capacity is to hold rights and duties, in other words, to stand legally and to exercise those rights and duties, while mental capacity refers to a decision-making skills of a person which naturally vary from one person to another and may be different for a given person depending on many, many factors, including environmental, social factors. Article 12 makes it very clear that unsoundness of mind, so dizziness and other discriminatory labels are not legitimate reasons for the denial of legal capacity. It means, therefore, that perceived or actual deficit in mental capacity must not be used as a justification for denying legal capacity. This, as also mentioned above, is very questionable in the Civil Code. Section 2.19 provides that the court shall place an adult under guardianship, partially limiting his capacity to act if due to his mental disorder, his ability required to take care of his own affairs is significantly reduced permanently or temporarily recurring manner, and consequently, having regard to his personal circumstances, family ties, and social relations, his placement under guardianship is justified with regard to specified categories of affairs. Also, Section 2.21 provides for the full limitation of legal capacity to act. The general comment also details out the normative content of paragraph 3 and paragraph 4 and all the obligation of the states as regards implementation. However, as being in time limit, I will not go into very much details about it in this presentation, but will analyze it in the article. If we look at the concluding observations on Hungary's periodic reports under the CRPD, so far there were two concluding observations. One was in 2012 and one was recently in 2022, 20th of May, it was issued and published. We find a comprehensive critique of the Committee on the implementation of Article 12. In the first concluding observations, which was issued in 2012 before the adoption of general comments on Article 12, the committee took note of the fact that Hungary is undertaking efforts to harmonize its national legislation with the provisions of Article 12 of the Convention. It welcomes at that time plans to provide for the supported decision-making in drafting the new civil code. However, it is concerned about the possibility of maintaining a modified regime of the substitute decision-making in the drafting of the new civil code. The committee was also concerned that the process of drafting of the new civil code has not been used to provide for a detailed and viable framework for supported decision-making in the exercise of legal capacity in accordance with the provisions of Article 12 of the Convention. At that time, the committee recommended that the state party, so Hungary, use effectively the current review process of the civil code and the relate laws to take immediate steps to derogate guardianship in order to move from substitute decision-making, so all forms of guardianship, to a real supported decision-making which respects the person's autonomy, will, preferences, and is in full conformity with Article 12 of the Convention, including with respect to the individual's rights and her own capacity to give and withdraw informed consent to medical treatment, to access justice, to vote, to work, and to choose a place of residence. The informed consent to medical treatment and to choose the place of residence from one's free will are particularly important from the point of view of elderly rights. In the second concluding observation, which was just issued now on 20th May 2022, the committee noted that the discriminatory nature of restriction on the legal capacity of persons, so the one already referred to above, with a disability on the basis of impairment, the absence of measures to abolish the discriminatory provisions of the Civil Code, and the persistence of the substitute decision-making regime, depriving from persons with disability of their rights. So the guardianship, actually in the form of today, is a questionable institute. It noted as well that attributes of the substituted decision-making regime have been, even though it has been retained, there are still steps to be made forward. The committee therefore recommended that Hungary, in line with the Article 12 of the General Comment, previously referred to, recognize the discriminatory nature of the substitute decision-making regime, so the guardianship, and abolish all provisions allowing restrictions on the legal capacity of persons with disabilities on the basis of impairment. Adopt a mechanism to restore full legal capacity of all persons with disabilities, regardless of their impairment. And also revise all provisions as regards the supported decision-making mechanism with the aim of ensuring that it respects the dignity, autonomy, will, and preferences of persons with disabilities in the exercise of legal capacity by all persons with disabilities. One may conclude that the existing Hungarian framework does not sufficiently address the recognition of disabled and those disabled as a result of aging before the law, and does not represent the rights-based approach required by CRPD. My research and article will further examine the possibility of the adjustment of guardianship as a substitute decision-making in Hungarian national law. Thank you very much for your attention.
Thank you, Professor Marta. Thank you very much. In line with today's agenda, I'm asking Professor Marta Osuchowska, could you present your lecture?
Yes, of course. Good evening, everyone.
Yes, please.
Yes. Today I want to present the most important result of my research on job opportunities for seniors in Poland. I have to tell that the pension benefits in Poland are not high and are not sufficient to meet the basic needs for most of our seniors in Poland. As a result, pensioners are increasingly choosing to take up additional employment. This is a very good way not only to earn money, but also to increase the amount of their pensions. This is because the law states that a pensioner who meets certain conditions has the right to apply for a recalculation of their benefit. For the reason it is worth earning extra money while retiring or, if there is such a possibility, delaying the moment of retirement, which can significantly influence the amount of pensions they receive. One way to increase the future pension is to delay leaving the labor market. Well, this may seem like a difficult decision for many people. After all, they have already had many years of work and would be happy to take the opportunity to retire at the first possible date. The figures speak for themselves. But every year of working beyond retirement age noticeably increase the future benefit. Each additional year of work increased the pension by from 8 to 10%, which in the following years, when our labor force will be considerably smaller, will also make it impossible to add the pension already received. If, however, we decide that the time has come to retire and our benefit unfortunately turns out to be low, or there is a need for additional expenses, which for there are not enough funds from our pensions, we can take up employment. But it may turn out that those pensioners who have not reached the general retirement age, for example, those who draw an early pension, may they have pensions suspended or reduced, depending on how much income they receive. And about that, I want to speak today. Pensioners who have reached universal retirement age, it's 60 years for female and 65 years for male, can all add their benefits without any restriction in Poland, which means that they do not have to worry about it. Those who have not yet reached the universal retirement age and who want to earn extra income on top of their pension, unfortunately have to expect to comply with the restriction in place. This is because additional earning may result in the suspension or reduction of the amount of pension collected. Pension to the Act of the Old Age Pensions and Disability Pensions from the Social Insurance Fund from 1998, the amount of a pension or disability benefit due may to be reduced or the right to such benefit suspended if their benefit received earned income affecting pension entitlements above a certain threshold amount. Retirement does not have to mean the end of career. Many seniors continue to work despite reaching retirement age. Over the past few years, the number of working pensioners has increasing by around 30%. The largest number of working pensioners in Poland reside in the Mazowieckie voivodeship, and this is the center of Poland where we live in Warsaw and Mazowieckie. It's about 16%, and the Śląskie voivodeships is about 15%. Well, the smallest number is in the Podlaskie voivodeships. It's in the northeast Podlaskie. It's about only 2%. The majority of working pensioners are women. Whose pensions are sometimes significantly lower than those of men. Working female pensioners account for about 56% of working seniors. Almost 19% of working pensioners are age 60, 65 and over. Continuing to work is a good way not only to earn more income, but also to increase the size of pension, that I meant. The legislation stipulates that a pensioner who works and has social security contribution paid on his or her contract is entitled to have his or her benefit recalculated to take into account the additional contributions. The economic situation of pensioners in Poland is not among the best. Low pension benefits are the order of the day. The situation is also not improved to the obligation to pay income tax or pay on pension and to pay social contributions. Many people who have passed the retirement age are still in their prime, which is the way to choose to remain economically active. Pensioners are always welcome to be potential employers in Poland. This is due to a number of concessions that an on reparent can count on when employing seniors. There are a number of companies, such as security, for example, security agencies that even characterize themselves by having almost exclusively employees which either a pension or a disability certificate. Working on a pension is also profitable for seniors themselves, as in many cases such an employer receives a full pension in addition of their salary. So we have two questions. So what concession can an employer who decides to employ a pensioner count on? And the second question, how can a pensioner combine a pension with a continued employment? We'll start with the second question. So how can a pensioner combine a pension with work? When an employer reaches retirement age, it does not automatically mean that he or she has to retire and cannot take on any additional work. At the same time, the desire to continue working beyond the age of 60 for women and 65 for men can lead to two different situations. First situation, the pensioner can continue to work, but in doing so suspend his pension, so that the pension benefit increases. Or he or she can also retire, draw a benefit and continue working at the same time. The remuneration earned in retirement is not limited in any way. However, it must be borne in mind that earnings earned that significantly exceed the amount of the pension may reduce or even suspend the benefit. However, this only applies to the situation of those who have not yet reached retirement age. The amount of the pension or the suspension is influenced by the average monthly salary for the previous quarter in Poland. It's possible to earn additional pension without any consequences if the income is no more than 70% of the average monthly salary. If the salary is between 70 and 140% of the average monthly salary, the pension will be reduced. On the other hand, if the pensioner's income from the work exceeds 140% of the average monthly salary, the social insurance institution will suspend payment of the benefit. When deciding on additional work, it is therefore worth checking the announced limit at the beginning of each quarter. Not only people who have already reached the general retirement age can earn extra money without worrying about a reduction of their pension benefit. The following can work without restriction. We have three groups of this person. First, the person with the right to a partial pension, one group. Second, persons entitled to a pension from a war invalid from a stay in camps and places on confinement or from the survivor pension of such invalids. And the third group, person with the right to a military invalid pension in connection with military service or a survivor's pension of a soldier who death in connected with military service. And we have the First question, what does working as a pensioner look like from the employer's point of view? And this is second point of view. Depending on the type of contract concluded, the employer may benefit more or less from the concession with the employment of the pensioner entails. The most appropriate and protective of the interest of the senior employee is a contract of employment. However, for financial reasons, employees rarely opt for such an employment relationship. In practice, civil law contracts, such as a contract of mandate or a contract of perform a specific task prevail. Employing a pensioner under an employment contract will not save the employer. This is because an entrepreneur who employs a person receiving pension benefit is not exempted from the obligation to pay social security contribution. The position of a senior citizen generates to the same social and health insurance cost as the position of the person before retirement age. In addition, the employer is obligated to pay sickness and accident contribution. Only in the case of female employees over 55 and employees over 16 is the employee exempted for paying contribution to the labor fund and the guaranteed social benefit fund. Currently, an employer employing on the basis of the contract of mandate is also obligated to pay contribution, but there are a few exceptions. Namely, in a situation where a mandate contract in the only form of employment for a pensioner, then the employer is obligated to pay pension insurance, accident insurance, and health insurance. However, there is no obligation to pay voluntary sickness insurance. The contract for a specific work being the less favorable for the employee is the most favorable for the employer. Therefore, is the most frequently chosen type of employee contract. Also for the performance of the work, characterized by elements of the employment relationships for the labor law. The employment of a pensioners on the basis of a work contract does not give rise to the obligation to pay social, health, accident, or sickness insurance contributions. In simple terms, the employer is exempt from the contribution paid to the employee's account. The employer only has to pay income tax and the amount of the pensioner's remuneration. With the entry into force of the entrepreneurial law, the possibility of running one's own business without being obligated to declare it is the relevant registers became available. Pensioners can also take advantage of this opportunity. So we are talking about, of course, about the so-called in Poland unregistered activity. A person who has not been self-employed for the last 60 months can carry out additional gainful activity without being obliged to register a company. For obvious reason, checking of this type of activity is limited by income limits. It cannot exceed 60% of the minimum wage in a given month. And I have a few minutes. I can talk about the relief for pensioners in this year. Because from 2022, this year, we have a new relief introduced to support pensioners in continuing the work and career development. From this year, relief has been introduced for selected pensioners who, despite becoming entitled to a pension, temporarily give their pension and remain in work. The relief is available to women over 16 and men over 65 if they do not receive a benefit despite becoming entitled to a pension of survivor pension. So this is some new results from the political program that we called Nowy Ład. It's very a very big program. This our political program, our government. So summary. So those working on a pension payoff for pensioners, it certainly lasts. With the current level of the pension benefits, in many cases, earning a pension is the only way to make a decent living. However, those senior citizens who have not yet reached retirement age should be careful with the income they generate from their work, as too much remuneration can even lead to the suspension of the right to a pension. As far as employers are concentrated, there are few benefits to be gained from concluding employment on contract agreements. Therefore, it's not surprising that more entrepreneurs choose to employ pensioners on the basis of a contract for work. With this type of contract, this is no obligation to pay social, health insurance contribution for the employee. The only cost to remain income tax and the amount of contracted salary. On the other hand, in the case of seniors who would like to earn a small amount of money while remaining independent from their employers, and unregistered business may be a good solution. So this is all for today. Thank you for listening to my speech. Thank you.
Thank you very much, Professor Marta. Time for Professor Erika presentation. Professor Erika, you have 20 minutes.
Yeah, thank you. And I am very happy that we could meet by this way, and I hope I will have not a problem with my presentation, because I am a little bit far from Hungary, but because I have to take part in another international conference in Italy. So I hope it will be exist, and I try make my presentation, and maybe it could be good, or I hope. I don't know, do you see the PPT?
Yes, we see everything is okay. Thank you.
Thank you. So, okay. In my research activity, I had to work with the question of the protection, legal protection of elderly or from criminological and criminal legal point of view. And so this is a complex question, of course, and because the elderly and the criminal code law could contact in different forms. Earlier, I spoke about the situation of the elderly in the society, and about the situation of the offenders, elderly or old offenders in Hungary and in some other countries. And now, the last time I prepared with the question in connection with victimization and the victim situation of old people, because this is a special question too. There are most kind or different kind of crimes, and so the victimization process and the situation of the old victim people is different. This is depends from the type of the crime, but we could stated that the situation in the society changed in connection with the elderly, and so the old people has more interesting connection with the members of the society, with the companies and others. So the possibilities to become a victim is more difficult as earlier. So if we could say some words about the age-focused victimization, we could analyzed this question from three different groups of connection. It means that there are one type of criminal cases which for these crimes the age isn't a relevant feature or question, and or the second possibility is in connection with this group that this old age it's only facilitates the commission or committing crime. For example, frauds, because the old people are more open, more naive maybe, and sometimes they are so alone that they are it's a very good possibility for them to meet with another people, and so this is not naivete in connection with the age, but with other psychological features. The other group of the criminal cases, each absolute typical criminal cases, but the way, the method of committing crimes is special. I will say some words about the role playing methods in connection with old people. And the third group of crimes is special, has a specialty because among the victims are a higher ratio the old people, or have a higher ratio the old people, and this is a special situation. For example, the physical neglect is the bodily harm, and the physical neglect is very typical, or the so-called institutional violence. But this is my next part of the research activity, because this is a very, very, very special situation from criminal point of view. The elderly as victims, I prepared last time in connection or about this type of crimes, because this has so much special features, and we can not found these features or these type of characteristics of the criminal cases in connection with other victims or other age group of victims. So this is really very, very interesting question, and this is these crimes are homicide against parents, and it means that the number of crimes is not so high, of course, but one case is too much, and so if we spoke about the research results, we have to know that this is not a very high case number, but maybe it's interesting for us that the characteristics or the features of the offenders is very special in connection with these crimes, because, for example, 55% of them have or had a profession by the time of committing crime, and had a job and earning. This is the full-time job and regularly earning, and 15 that 5% of the killer had a university degree. So this is very, very special situation. We could see that the most part of this crime was or were committed in villages and cities, and it's mainly interesting the ratio of the punishment and the feelings of the offender in connection with their very harsh crime, because to kill somebody is the most dangerous criminal activity, and killed their or his or her parents is the most punishable criminal case, but we can see the results that about 50% of offenders didn't feel him or herself guilty in connection with this criminal case. And it's really and it's interesting too that about 40 part of the criminal cases, or in this part, the offender didn't have earlier criminal career. It means that this crime to kill his or her parents or parent was father or mother was the first criminal case in his or her life. So about 70% of them didn't use something substances, for example drugs or alcohol or medicaments before the committing crime. But it's really interesting that high prevalence of psychiatric disease could analyze and dates. It means that this is typically schizophrenia or personal disorder with, for example, schizoid elements. Most part of these children, but this is an adult typically. So these children felt his or herself in loneliness, and they didn't have life and impulsive connection with other people, so they are very alone in their his or her life. What we mean or what we know about this question, and this is the next very special feature of these groups of offenders, that a relative high ratio of or proportion of the offenders attempted suicide after committing crime. So it means that this crime was committed with a very high level of emotion and other feelings and or impulsivity. So it means that 75% of the crimes or the offenders, it was the real situation in connection with crime committing. So this is the high level of suicide. The tension is really interesting. The high level of mental status problems is interesting. The high level of educated offenders, the high level of first offenders is very, very special characteristics. And what we know that what was the childhood experience of these offenders, we could show these results that about 60% of them have been abused or neglected in their childhood. So it's a relevant high level of offenders has very, very bad experiences in connection with their parents from their childhood. And if we looking for the answer, the feelings, unguilty feelings and others, it means that these features or these okay, this features is very important role, or has very important role in connection with this, and this is the answer for the lack of guilt feelings, high levels of impulsivity, or the role of parents. So the mother and the father is we could see that it's different the ratio among the victims, but it's if we would like to make different groups of offenders and criminal cases in connection with this homicide, we could write three different groups. One is the adult offenders with psychiatric problems. The second group is adult offenders who was or were neglects her parents in need, and the third group of offenders is or were personally victims of previous child abuse, as he or she was child or minors. So this is three very different groups. The causes of the homicide is very different, and the answer and the solution if is of course in a different way too. And maybe it's interesting, the imprisonment, the term of imprisonment or the punishment in connection with this special characteristics of the crime committing or these cases. We could say that although this is a very dangerous type of criminal cases, the long or the term of imprisonment wasn't or weren't so long or so high years. The second interesting group is the elder abuse, and so we have to say what is the elder abuse, and we could say that this is a single or repeated action or the lack of necessary intervention or action. So it's very interesting or important in connection with the institutional violence, which act or lack thereof causes harm, fear, or unnecessary pain to the elderly person within a relationship in which trust can be expected. So the elderly abuse, or some words about the elderly abuse, we could say that there are different types of this abuse. For example, physical abuse, or psychological and emotional abuse, or financial disease, an interesting case too, and sexual abuse or neglect. But if we would say some words about the Hungarian research, this is the cases before the court, and it means that we could say that the abuser were children, in the most part, and in smaller part is parents, but we focusing on the other abuse, of course, were, or in these cases, the offender was children. The age of victims, we could say that relative high level, high ratio of victims were older than 80 years old, but the most part were between the ages 60 or 70. What we know about the offenders, that the majority are men between the ages of 26 and 35 years, and they are low educated, they have low income, and they don't have a long-term relationship, for example, a girlfriend or wife or others. So they are very lonely, and they are unable to support themselves on their own, and so they depend from their parents, especially not only emotionally, but sometimes emotionally too, but especially financial support gave their parents to them. What we know about the situation, that the proportion of people with a criminal record is 40%. 40% is a very high ratio, but it means that we spoke about the killers and about the homicides against parents, and we know that most part of offenders were first offenders, but here we know that about 40% of offenders have already a criminal career or criminal record, but this isn't in connection or typically not belong to the, or doesn't belong to the parents' cases or violent cases against their parents, but for example, criminal cases or crimes against property. What we know about the abusive behavior, this aggressive behavior towards the elderly were very different, and it's typically that somebody would like to prevent this situation. Mental illness is a relative often problem among the offenders, and the domestic violence was a part of this life history, offenders' life history. And what we know about the victims, we know that there are two different groups of the victims, or the typically groups. The one is the parents or foster parents or grandparents who has previously abused their family family. So they were earlier abuser against, for example, his or her husband or wife, but typically wife, and against the children. And later they became victims of domestic violence. And the second group is old people with bad mental state or other problems, and they referred to their children and grandchildren. It's interesting that the victims in the first group are typically men, father, grandfather, etc. But the victim of the second group victims of the second group were typically grandmothers or mothers. And we have other interesting question if in connection with the victim situation. This is newest court case research. It means that all or every cases were analyzed which have old people victims, and it means that this is a mixed group of victims and mixed group of criminal cases. There was in this year 266 victims, old victims, but it's very important to say that this is the official part of criminal cases, and we didn't know or don't know too much about the latency or about the cases which stay in latency, and it's really high level, but we don't have enough correct of victims were 78 years, and it's really old. And we know that most part, two-third part of victims were women. But we know the criminal cases, so the types of criminal cases. This table shows us that there are cases which belong, criminal cases which belong the crime types against property, and here have to we speak some words about this role playing methods. It means that the offenders phone the grandparents typically, and they play the role of his or her grandchildren, and he said or she said that I am his or your grandchildren, and I need financial support, and please help us, my dear grandfather or grandmother, etc., etc. And this is a very, very typical method to cause damage, financial damage to these grandparents or old people. There are violent crimes against property, for example, robbery, and we could say that most than 36% of the victims became a victim of this type of crimes. Okay, there are violent crimes to, for example, bodily harm, sexual crimes, but it isn't a high ratio. But we have to know that sometimes or typically, sexual crimes belong to the crimes against property. The offender would like to commit crime against property, but they met, or he or she, but he is typically met with the victims, and they use or committed not only violent in connection with got this I don't know, money or something others, but after this they or he committed sexual crimes against old women. Neglect is here another form. The place of committing crimes is, we know that most part of crimes were committed in the flat or house of victims, and this is a special situation too. The features of offenders, we know that very high ratio of offenders were men, and the ages is, we know that between the ages 25 or 40 were the 40% of offenders, and older was 31%. So the most part of offenders belong to adult. They have not too high level education or educated. It means that about 50% or half of offenders finished only the elementary school, but 15% of them finished or became that without the elementary school finish. Work activity, we need, we have to say that more than half of offenders has not legal income. It means that these features is absolutely others than the earlier two groups. So the domestic violence or the homicide is very special criminal cases. What we know about the victims, the social and health position, we could say that the victims typically were not physician diagnosed disability or hadn't physician diagnosed disability, but about 30% of them were old and had something form of disability or physical health problem, for example, locomotor problems. 1/5 of them had mental problems, especially senile dementia. And what we know, loneliness is maybe interesting in connection with the old people. We could say that 30% of victims lived completely alone, and it means that they didn't have real contact or contact with anyone. So absolutely alone, and 30% of them meet only one times per week with their relative, but is not personally meet, sometimes only a mobile phone or connection. The other is that who could give some help to the victims, and we could say that about half of victims didn't receive some help from anyone. because of suffering the crime. About 40% received help immediately after the crime, and the people who could give something help to these victims were typically neighborhood or the relative of these people. And it's interesting too that how could make something against the crime these people. I don't know, this is here the defense. It means that about 50% of victims didn't defend themselves at all, so they were old, they were not enough strong, or they were psychological shocked because they became victim in his or her or their private house or flat. And sometimes the old people tried shouting as a defense form, and it's very important that about 30% of people or of victims who tried to help, tried to ask help from neighborhood or relatives or other peoples in the near didn't get this help, and no other person helped to them, although they hear the shouting, or they knew that something happened with these old people. Yes, and the social or the, for example, the nature of the crime, that most part of the crimes belongs to the situative crimes or situational crimes, and it means that not earlier connection are between were between the offender and the victim, and they most that 60% of them didn't know each other before committing crime, and the most part of the crimes have absolutely financial gain or the form of and the degree of violence. More than 30% of victims unfortunately died in connection with these violent crimes, but about 33% of victims were not injured. It means that the ratio or the strong or the level or degree of violence were very different in these situations. But it is only one thing, that they were not injured physically, but the ratio of psychological injuries is very, very high in connection with old people, and in connection with this feature that they became became a victim in their own flat or house. Okay, and maybe it's interesting too that oh no, this is the last. Interesting too that the connection or victim interaction was a special. 6% of them behaved in a provocative and abusive manner. But most part of victims were earlier, for example, many years ago, as parents and abusive parents. But at the time of crime committing, we could say that only 6% gave behavior provocative or abusive situation, so thus contributing to the escalation of the situation to a small extent. So this is the sources of current bibliography, and thank you for your attention.
Thank you very much, Professor Erika. Perfect presentation, like usually. Thank you one more. Last but not least, Professor Konrad Walczuk. Time for your presentation. Professor Konrad Walczuk, are you accompanying us? Do you hear me? I see that he is present, but I don't know why he doesn't hear me. That's a pity. So
he's writing in the chat.
Köszönök akkor. Dear professor, excuse me, I don't know, it's a problem that I have to go to the conference back because it's doesn't finish today program, and I don't know, could I leave our meeting today, or we will continue with
yes,
other
please,
questions.
if you have another conference, you can go. Thank you very much for your present, and see you in a month.
Thank you.
Maybe Professor Zsuzsa, you lost connection, so I started with my lecture. Could you finish your presentation now? Now it's
Yes.
it's a good time for that.
Oh, okay. It's very good. Thank you for the next chance. I changed the internet accession, so I'm in a mobile internet because the network is over, so I can finish my my closing remarks.
Yes, exactly.
Okay. Do you hear me?
Yes, everything is okay.
Okay. So my closing remarks and my de lege ferenda proposals that Hungarian civil law guarantees the right of contact of grandparents among elderly relatives established by law according to the provisions of the International Legal Convention in force and the provisions of EU law. But with regard to the right of contact of elderly relatives, the question arises as to whether the line can be drawn as to who can have contact with the child. The civil code among elderly relatives, it ensures the right of contact for the grandparent. But can the great-grandparents' contact rights be limited on a constitutional grounds? This is the question. The general conclusions regarding the protection of the family can be drawn by fundamental law of Hungary, that the state must guarantee contact within the family, especially between those relatives who are in direct kin relationship, including the great-grandparents' right to contact. According to the civil code, I don't know that do you use this special word, that kin relationship, that lineal kin relationship exists between those of whom one originates from the other, the parent and the child, and the grandparent and the parent. So it's a lineal kin relationship. So it could be better. It could be a contact relatives who are in a direct kin relationship, including a great grandparent. On the one hand, it would be well-founded to extend the range of persons entitled to contact to all elderly relatives who are in a direct kin relationship, because there is no constitutional basis for the law to withdraw the range of the person entitled to contact at the grandparent level. This proposal is harmonized with the provision of the cited International Legal Convention, in particular, the Council of Europe Convention on Contact Concerning Children, and with the European trend that has tended to broaden the circle of persons who has right of contact. But on the other hand, the child's private life must also be taken into account when broadening the circle of persons entitled to contact. So if we imagine if the child has to maintain contact with his separate parent, with his 4 grandparents, and with his 8 great-grandparent, of course, I know that this is a very extreme situation, then his life will consist of a series of contacts, and he will not have time for activities due to his age chosen by him, which is absolutely contrary to the child's best interest and the child's rights. So in view of all this issue must be handled with reasonable limits by coordinating the interest of the person interested in this legal relationship. And I think it's a very, very difficult situation. Almost probably we can say it's an impossible mission. Thank you for your kind attention.
Thank you very much, Professor Zsuzsa. So in our agenda, we have time for discussion. We will move on to the discussion and question part. Are there any questions? Maybe do you have edit some statements?
If I have some comment
Yes, please.
It's not problem. Marta Benyusz talked about the supported decision-making system. It's a comment, not a question. The supported decision-making I deal with in my paper, in my second paper, the supported decision-making procedure or a legal institution, which it could be an alternative of the guardianship, but I think that it's Hungary. It doesn't work. It's not a good system. So if we have to change the guardianship to another system because of the CRPD, and we have to choose another supported decision-making system, because I can tell you the statistic. There are only 150 cases per year of supported decision-making, and it's absolutely it couldn't be an alternative of the guardianship in Hungary. So I would like to comment only some sentences, and sorry of my disability of accessing a good internet. This is one of the problems of the elderly. Access a good internet.
Thank you very much for your comment. Maybe we have a guest. Maybe our guest has a question or comments. No. I have also one question. In this situation to Professor Marta Osuchowska, if I can.
Yes, please.
Yes, thank you. Professor Marta, should elderly people work for the rest of their lives? It means are they forced to do because of their low pensions? What do you think? Maybe the state should support more serious than today.
Yes, I think the most important case is that they really need some more money, especially nowadays that we are got this great inflation. So I think it's the most important reason that they got. But I know that the pensioners that they really want and they need to work because it's very important for the health, not only for the physical health, but the dimension of health. It's also very important for that one. And I think that it's the most important thing because when we are looking for the reason for this last law that we've got since this year, this January, I think is the most important reason that they really need some more money, and not only this extra money, but the increase their pensions. Yeah, it's this is the main reason. I think it's the main reason that I was looking for the reasons why they are working. The seniors and the most of them, more than 90%, they're speaking that they really need some extra money, not for the future, not for the extra money just the retirement, but the extra money for this day. Nowadays, they are really need some extra money for the health, not only for the extra money for I was looking for before my last theme of the subject of my research was about the cultural activity in this area, and it's not for the cultural area. And the most that the 90% of the reason the extra money for the seniors they need this extra money for the health, for life, for buying the food, and this case that is not for the spend for the vacation or the other extra money. No, it's only for nowadays. Yeah.
Thank you very much. I asked you because I personally afraid to work till to retire because of issue of because of problems with health, lack of willing to work, possibilities, and so on.
No. It's this the subject is very important for me because my mother, she's got 74 years old. She's 74 years old, and she's working at the full time, and she's also a professor, and she's working very hard. So I don't know when and. She want to go to retire. I think she don't want to retire. It's the whole life the work. Then it's not only money, but it's only it's about only 5 to 10% person that they really want to work because they live for the work for their work, and but the most of persons say the people that really need to work to have some money because so nowadays we are talking about the very big inflation. Yeah, we are talking about for example, now I'm not in Warsaw, and while I got talking with my neighbors, in the small city in the south of Poland, and they are talking about the cost of coal this year. That there's about the cost of coal this year is about 3 or 4 pensions per day. It's a lot
but
of
it's a
money.
specific time
Yes.
nowadays, so it's
But
not
they
normal
are
time,
living
yeah.
now, and they need
Yeah,
this
I know.
money for this. Thank of God, we've got 20% now, so it's not very bad time. But they're thinking about this winter, well, how they can buy coal. Yeah, it's very big problem for many of seniors in Poland now.
Yeah. Probably in Hungary is the same or very similar.
Yeah.
I don't see any questions, any comments. So maybe any other matters we should discuss. So we do our job for today. I would like to remind you that the deadline for delivering monthly reports for October is approaching. We will meet next time in a month, probably